Okay, we're going to go ahead and call this work session to order. We'll start with attendance.
Pete Peterson, Assembly.
Tim Steele, Assembly.
L.V. Gray Jackson.
Bill Evans.
Ernie Hall.
Amy Kowalski.
Joe Levesque, Special Counsel to the Assembly. Patrick Flynn.
Okay, and as everyone here, I believe, knows, this is the subcommittee's finding in the Eberhardt versus MOA remand issue. The easiest way to go through this, the subcommittee has taken multiple days to go through in our deliberations. Joe's going to actually set it up and go through what we were required to look at by the court, how we went through the process, and ultimately what our findings were. Today what you have in front of you is actually an incomplete draft. It's almost finished. Essentially it has all of our findings. We just need to finish up and add a few little details regarding the conclusions of law. But essentially it was a very complicated topic, but I feel we came to a good decision. So with that, Mr. Levesque.
Yes, Madam Chair, members of the Assembly, to the public. My name is Joe Levesque. I'm Special Counsel to the Assembly in this matter. I'm just going to briefly go through the timeline, what's happened, and then we'll address the actual draft. So, the history of this, of course, is an area in Anchorage that everybody is familiar with. It's the Turnagain Heights or the Turnagain Slide area. And after the earthquake, that area was not available for development. It was in the Anchorage Bowl. It was the hardest hit area, as everybody knows, because of earthquake arc and all of that. So after the earthquake, the municipality did give landowners other lots, but it did not take possession of their interest in those devastated lots. And so many landowners continue to be interested in developing those lots. And they're, it's in a very nice location in Anchorage, of course. But there were some requests that happened early on from people just showing an interest in maybe getting the municipality to do something. But the municipality's budget wasn't to go in there and use its own resources to build. It expected, either private development or a request to go under the special assessment provisions in the code. And so early in the 90s, there was, in fact, an effort by some of the property owners to build the infrastructure that needed to be built for a normal neighborhood in the municipality through private development. And they ran some numbers and they took a poll of the community. And there were maybe 5 lot owners that were not interested in any private development. And so the people that were spearheading that decided, well, it's either all or nothing. And if you can't have everybody involved on this, then let's look at a new plan B. And so petitions were submitted to the Assembly to form special improvement districts for water, sewer, and road. And those improvement districts basically had an estimated cost of what it would be, and as soon as the voters, the lot owners, voted to approve those districts, well, that meant that everybody in the district, even if they were against it, were now committed. And so those original engineering estimates that they were working on, once approved, the municipality had some design engineers actually look at the project and what had to be put in there for infrastructure. And the original amounts raised they raised quite drastically, quite a bit. And it was in the tune of, and I'm not going to give you the exact number, but let's say that originally the estimate was around $3 million. Now the estimate, after the engineers took a look at it, was up to $7.3 million. And so that caused the municipality some concern, because obviously the property owners had not approved that kind of money. And so the municipality went back to the property owners and said this needs to be reballoted. And the property owners again approved the special improvement districts for water, sewer, and the road. It's Marston Road, if anybody's familiar with that. And so the municipality went ahead and started the design, and they ended up, at the same time, there's a pump station that really wasn't up to par. It wasn't doing what it needed to do for the growing community. And so there had been an interest in maybe developing a new pump station or repairing the old one, upgrading it in some way. And in the end, the municipality decided to actually change the site of the pump station, and to change the site in consideration of this special improvement district that was also wanting to be built at the same time. And so the municipality ended up combining the engineering for both the pump station and for the special improvement districts, the WID, the LID, and the RID together. And they thought that made sense because both were going to be built. But the pump station 10 was being built by AWU. It was a capital improvement project that the municipality was going to build and pay for. And so eventually, as things got closer to the bidding stage, the municipality made a decision to actually bid both of the projects together. And I'll talk a little bit about that as we go through the actual written findings. But what happened was, once the construction was completed, the construction occurred in 2008, 2009, it was completed in 2010. And once it was completed, it took a while for the municipality to get the actual assessment numbers. Even though the voters had approved the amount, they didn't know what the actual out-of-pocket cost would be. Each lot was different, as the assessor testified. The size of the lot, the location, i.e. bluff lot, the view, everything makes a difference as far as the assessment on that lot. And so when the assessment numbers came out, and it went again before the municipality to approve those final assessments, a lot of the lot owners, and it may have actually been just a handful, but a number of them went forward and wanted to actually go to the assembly and submit some sort of evidence and testimony to the assembly saying, wait a second, we have problems with this. And the first time that they were scheduled to do that, it was postponed. And in the meantime, the assembly chair was changed. And when it came back up to the assembly, the new chair said, hey, this is already done, the record's closed, we're not going to have any more evidence or testimony. And so the assembly went ahead and adopted the final assessment numbers at that time. And the property owners, or at least some of them, got together and hired an attorney to actually file a Superior Court claim. And the complaint in front of the Superior Court, the number one issue was, hey, we were denied due process. We went in front of the assembly, we hadn't seen the whole record, we weren't allowed to introduce our evidence, and we weren't allowed to give testimony. And so that went to the Superior Court, and the Superior Court said, well, hold on here, wait a second. I understand that the Assembly generally, when it does these types of assessments, just has a legislative hearing. But in this case, because of the issues, and because the property owners were not afforded the right to provide evidence, to look at the record, or give testimony, and because of the issues, I think it needs to be remanded back to the Assembly. And the Assembly needs to, one, provide due process, and two, it needs to look at several of these issues that have been raised by the lot owners and make a determination, because I need, in order to review as an appellate court, I need some sort of a record and a meaningful decision that I can look at and actually decide whether or not I would agree with that or not. And but if the municipality fails to do this, which I'm remanding it back for, then I will do a de novo trial, and that means I will look at it, without the municipal participation, and I'll make a decision as if nothing ever happened. So the municipality, upon getting that order, took it very serious, and didn't appeal it, didn't make any arguments. It just said, okay, fine, this is back to the municipality, so how are we going to handle that? And so when I got involved, the idea was, instead of having all of the assembly members involved in this, because it is a very complicated case, and it took a lot of time to ferret through all of the evidence and the testimony and the facts, the Assembly decided to actually set up a hearing panel, and that hearing panel is chaired by Mr. Dabowski, and Mr. Evans is on it, and also Mr. Trainey. So those are the hearing panel that I worked with. And the hearing panel was especially concerned with this due process question, because obviously, local governments want to afford due process to their citizens. And so a lot of care and coordination took place between the clerk's office and also with the agencies involved, the municipal agencies, AWU and Public Works, to make sure that there was adequate notice given to everybody as far as how this process was going to work. And in addition to that, the panel working with the clerk's office and with the two attorneys that are involved. The one attorney is Bob Owens, and he represents the municipality, and the other is Michael Staley, and he represents the lot owners. We sat down and we drafted out a process and a procedure that would be followed. And we called it a stipulated agreement between the parties as to how this process was going to occur. And both parties signed off on that and said, okay, this is adequate, let's go ahead and proceed. And so eventually we had to set an adjudicatory hearing, because that's what the judge said. You can't have a legislative hearing for these issues to be heard. You actually need to adjudicate it. And so the adjudication hearing, the adjudicatory hearing was set for, I believe, in September. But then there was a motion to continue by one of the attorneys, and so then it was reset for early December. And so on December 1st, 2nd, and 3rd, this panel that I described actually spent 3 days listening to the arguments, the evidence, the testimony, and spent, if it wasn't 8 hours a day, it was close. I think some days were shorter, but other days were longer. So it probably averaged out to about 8 hours a day. And at the end of the adjudicatory hearing, the panel decided that what would be helpful, because of all the testimony that we received and all the evidence, is to actually get some findings of fact and conclusions of law submitted by the parties to the panel, so that we can look at that and help us, as we deliberate, go through this process. And so the panel did deliberate a couple of times, and went through the findings and went through the evidence, listened to some things, went back and reviewed specific exhibits, which were evidence. And then it was my job, after the panel advised me how it had decided the various issues, to draft. And this packet that I've just given you, this document, is in fact the draft of the findings and conclusions. And Amy Dembowski had mentioned that we're still filling in a few things, and basically what we're doing is we're going back and checking the citations, because we had so many pieces of evidence, and some of the evidence was marked as evidence for the pre-hearing or the hearing brief, and it had different exhibit numbers than evidence that was submitted during the actual adjudicatory hearing. So you have to go back and forth and sort through. So we want to verify that all the sites check out okay, and also add some of the law that we haven't added. There is some mention of law in here, but we need to buttress that by actually adding the law that the parties argued into the document. And then finally, we're going to add a conclusion. And so once we have this, the Superior Court will have evidence that the Assembly did what it was instructed to do, and it will be able to review this and make a decision regarding this, but as an appellate court, not as a court of first right. And so that's the short history, and then we have the document. So if you don't mind, unless there's questions, I'll go ahead and go through the document. So. And I should mention that as part of the due process, one of the things that the Assembly decided to do was to go through and disclose any conflict of interest or potential conflicts of interest, or any or not quasi, but any ex parte communications that have occurred, because this is a highly contentious issue, and members of the public may want to talk to assembly members about it, but the assembly members were not entitled to do that, or if they did do it, they had to disclose. All of that's taken place. Next Tuesday, when you have before you the new revised assessment numbers, you'll have the final draft in front of you at that time, and you will once again, as I understand, go through that litany of disclosing any potential conflicts or ex parte communications, because we want to make sure that those are avoided.
And before you go any further, Mr. Trainey's joined us, and Ms. Gray Jackson has a question.
Thank you, Madam Chair. So even with this document, was it always, God, how can I word this? Did the Supreme Court always be the entity to have the final decision?
Well, the Supreme Court will have the final decision if
Right.
it goes that far.
Oh,
The
okay.
Superior Court is who remanded it back to the
Okay, I'm
Assembly.
sorry, I meant to say Superior Court.
Yeah, there is, as we speak today, that action that was filed by the plaintiffs, let's say, or the appellants, the property owners, still exists, and it's ongoing in the court system.
Okay. So if I can follow up, Madam Chair, so this decision has to still go to the Superior Court for the judge to make a decision on an action,
And
whatever
unless
the
the
phrase may
parties
be.
take this, accept it, and just dismiss all of their litigation.
Gotcha, understood.
Then this document will end up in front of the judge.
Okay, thank you. Thank you, Madam
That's why it
Chair.
has to be perfect.
So the way that we structured this, so that it's readable and it's easy to follow, and I should mention to the panel, to the hearing panel members, that this has changed from the draft last night, because I might have mentioned that we wanted to reorganize parts. And so just check the other drafts. This is the most recent. And as far as the hearing panel, when you're going through this, if you can think of any other evidence, or if you disagree with evidence, I need to hear that, because this is your document. Okay, so the introduction just explains some of the things that I've already covered about the special improvement districts and the area, and how the matter was remanded back to the Anchorage Assembly. And before the issues are actually presented, it discusses that after hearing and carefully considering all the evidence presented, the Assembly of the Municipality of Anchorage accordingly issues this decision and findings of fact and conclusions of law. And I'm on page 3 now. It starts listing the actual issues that are presented for review. And it starts with, on page 4 in the middle, it starts by well, I should go to the top first. When the judge remanded it back to the Assembly, he noted that the Assembly does in fact have a procedure process in its municipal codes that would allow it to perform this adjudicatory hearing function, and that's the reference to 3.60. So that's where you find that, and the scope of that is laid out further on. But the way that we handled this was we identified the two main issues that the appellants have, and those are listed in the middle of page 4. And those come out of the briefing that the appellants performed, where they said we really have two issues. And those issues are, number one, whether the special assessment exceeded the value of the benefit conferred upon the property owner taxpayers. And the second is whether $1 million of the cost of constructing pump station number 10, the lift station, as it's also referred to, was improperly shifted to the improvement districts. So those are the two main issues that the appellants have brought forward. But in addition to those, when the court remanded it back in the court's order, it had two other procedural matters that it wanted the Assembly to follow. And then it had 4 issues that it specifically said that when the Assembly goes back and listens to this and hears this and provides all of the due process, I would, as the judge, like the Assembly to address these 4 points. And so there's some overlap between the appellant's issues and what the court has instructed the Assembly to deal with. So as far as the procedure, what the court ordered was that the Anchorage Municipal Assembly must have a reassessment of those numbers. They have to be reassessed again. And the municipality has done that, and that's what you're gonna deal with on Tuesday of next week. And that's pursuant to both this 3.60 adjudicatory hearing process and the special improvement district provisions in your code. And so that's been taken care of, and then it says that the municipality must provide this adjudicatory hearing. It has to be held. And rather than a legislative hearing, it has to be adjudicatory because there are these disputed fact issues, and that's what the judge demanded. And so then the judge said, here are the 4 issues that I really want you to deal with, and this is on page 5. And he said, I want you to deal with whether the lift station project construction costs were improperly imposed on the lot owners. I want the assembly to make a determination on that issue. And I also want the assembly to decide whether the assessed costs included the addition of an independent lift project that was not approved by the ballot of the lot owners. But the lot owners basically say that they were never informed of how this was going to be bid out, and they're concerned that some of the costs that really benefited Pump Station 10 was somehow shifted over to them and improperly. I mean, is what they state. So the judge wants you to deal with that. The judge is also concerned about the bidding procedures and whether or not they were properly implemented by the municipality. And finally, the judge said that the assembly needs to make a determination regarding how costs are offset. And the reason that the judge was dealing with that is because one of the appellants owns some property in this area, and they actually had a home with road access and utilities. And there was never any kind of an equitable adjustment made, and notwithstanding there are many demands for that, and also notwithstanding that the property owner adjacent to their property also was in a similar situation, had a home, had road access, had all the utilities. And that property owner was in fact given an equitable adjustment by the assembly. And so the judge wanted to make sure that the municipality was aware of that, and that it basically had dealt with offsetting that. Because obviously if the new road and all the utilities don't really benefit the homeowner, then how can you say that there was value conferred through this construction process? So at the adjudicatory hearing, and there's actually part of this just sets out on page 5 how the adjudicatory hearing process was put together, and how the pre-hearing stipulation established all the dates. And so the hearing was held on December 1, 2, and 3 of 2014. And at the conclusion of, and I've already mentioned this, at the conclusion of that, this is on the page of top 7, the parties were requested to submit findings of fact and conclusions of law. Now, section B on page 7 is there to provide evidence of all of the due process that occurred by the municipality to the affected property owners. And it, if you go to that, you'll see that the municipality provided an abundance of procedural due process, all kinds of notice. Basically said, here's the record, go through it, it's yours, which it had failed to do before, and has also given the property owners this adjudicatory hearing process. If there were property owners that weren't part of the case, the case that is running at the same time as this appeal, those property owners were also invited to come forward and provide public testimony or public comments, and a couple actually did. But at the top, the bottom top of page 9, what is stated in the decision is that the municipality has now provided an abundance of procedural due process, including multiple notices to the parties and landowners, and a comprehensive record of appeal or on appeal, several public hearings allowing participation of the parties, and an adjudicatory process where the parties were allowed to present evidence, cross-examine witnesses, all of those things that are done in a trial-like setting. And then on the bottom of page 9 is where Anchorage Municipal Code section 3.60.050 is actually set forth, because it provides for the adjudicatory hearing. This is what the judge pointed to and said, you guys need to follow this. And it says, unless otherwise provided in this code, officials, boards, or commissions empowered to conduct quasi-judicial proceedings may hear and decide de novo all matters appealed, and may exercise independent judgment as to the weight of the evidence supporting or refuting the findings of the administrative official, agency, board, or commission from whose decision the appeal is taken, and may exercise independent judgment on legal issues raised by the parties. Decisions of administrative bodies or officials may be modified, remanded, or affirmed by the reviewing official, agency, board, or commission. And so that is the scope of the adjudicatory hearing. That's how, what the panel understood that its role was. And so, starting on page 10 is where the actual findings of fact and conclusions of law is first listed. And there's an introduction and background. And I'm just going to go through this slowly. It's going to complement what I said in my introduction. But it basically describes the area. It talks about the earthquake. And it talks how that owners of those lots were not allowed to build until certain things were done. And for this area, there actually was a prohibition for development for many years. And so it took, approximately 15 years for landowners before they were allowed to even think about redeveloping this property. And what the municipality had was, it had Emergency Order 77201, which was issued in 1977. It specifically prohibited any development in that slide area until a plan or approach for development was adopted. And several ordinances then followed after 1977, and they basically said, we're going to continue to put this area on hold until we have analyzed the area and see how development can best be done. So in 1978 is the first time that the Assembly passed an ordinance establishing specific development requirements for 130 land parcels in that area that's the Turnagain Slide area. It's not just the area that's before you, because Turnagain has west side, east side, this side, that side. Some areas were developed before this area was developed. So in the meantime, the geotechnical investigation of the area continued, and that's what the Assembly was waiting for. So the first area that was approved for development is what's known as the Turnagain Northeast side. And there was a geotechnical investigation that reevaluated the stability of the ground, and the study affirmed that the land had settled more than it was before the earthquake, and that limited development with restrictions were acceptable. And so that area went in at the request of residents in 1995. Or actually, it might have been before that, but in 1995, and I'm on page 11, the residents of the area made a request. Actually, the municipality, at the request of the residents, commissioned another geotechnical investigation to reevaluate the area. And during the early 2000s, this is when some of the property owners were actually requesting that the municipality start developing the area that we're talking about today. And then about the same time, in the early 2000s, is when some of the lot owners got together and said, we can probably develop this on a private basis and save a lot of money, because they were aware that if you go through the municipal special assessment improvement district method, you lose control of your development, and it's also going to cost more than a private development. And so they tried to do that. They couldn't get everybody on board, so they decided, we'll go to Plan B, which is to petition the municipality to do that. And now, at that time, there is a body that's called the Geotechnical Advisory Committee that the municipality has. And at that time, there were no GHC requirements in that area. But as the process went forward, you're going to find out that the municipality actually stated in an ordinance that any development that occurs in there has to go through the Geotechnical Advisory Committee. So different lot owners testified at the adjudicatory hearing. One, for instance, was Mr. Spinelli, And he was critical of the municipality and how it handled the assessments, but he admitted that he knew it would cost more through this process. And he also admitted that this $1 million, that is a major issue, whether that money was shifted from the pump station to the improvement districts. He testified that he even didn't mind paying for that, but he was upset about stub outs, because when the construction was completed, stub outs were not laid out the way that they should have been as far as he's concerned. So it's going to cause anybody that wants to go in and develop in this area that's been improved to actually dig down a good distance and run their connections to those stub outs. And so he was a little upset about that. But he testified that he voted in favor of it twice. The first time when it came before him and it was around $3 million, he voted in favor, and the second time when it went up to $7.3 million, he voted for it. And so the first numbers that came through were actually, I'm on page 13, were in September of 2003, and the municipality provided preliminary cost estimates to the landowners so that they could vote on whether or not they wanted to go ahead and form these improvement districts. And at that time, the cost estimates were $1,900,000 plus for constructing the road, so it was under $2 million. And for the sanitary sewer, it was like $800,000, and this is on page 13 at the top. And then for the water improvements, it was going to be just about $500,000. And so that's what the landowners, the property owners, initially voted in favor of those. But as you'll see in the findings of fact, not all the property owners were in favor of development. In fact, there were a number of them that didn't want any improvements at all. In fact, there were a number of community residents in that area that would have preferred that area just remain as some sort of a park, for the Turnagain area. And so there were different parties arguing different politics. But the balloting closed for the first time on October 31st, 2002. And 59% of the property owners voted in favor of the road improvement, 70% voted in favor of the sewer and the water districts. And so the assembly then went forward and actually approved the creation of these special improvement districts and authorized work to proceed beginning in April of 2004. And there was one group, for instance, that called itself the Citizens for Turnagain's Future, that provided evidence to the Assembly requesting that the Assembly defeat that ordinance. And we've gone ahead and listed what those property owners' 10 reasons were. And those are all listed on page 13 and 14. And so the Assembly knew that, part of the arguments at the time were that, the area really hasn't provided comprehensive planning. The municipality should not subsidize the development. There are speculators who want, all of this to happen, but we don't really have the new studies, the new geotechnical work, to prove, to actually show that this is going to work without causing danger to the area. The project will cost more than the current estimates, and at that time, these speculators, whoever they are that they're listing, will attempt to push the costs on the public. And if you adopt this ordinance creating these improvement districts, then you're basically forcing people that don't want to do this to do it, and they didn't want that. They were concerned also about the density, that if you put a road in, there's going to be more neighborhood traffic, and it might endanger children and so on. So I mentioned earlier that when you look at the ordinance that actually authorized the creation of these improvement districts, in its ordinance AO 2004-2 as amended, it specifically says that that the design of the public improvements has to go through that committee that I talked about, the Geotechnical Advisory Committee. So a number of the witnesses, I think we've listed it, I think there were like 14 witnesses that actually were, provided testimony, were cross-examined, some were recalled back. I mean, the panel had questions, and then there were a couple people that provided the public comments. But the district had to be run through the the GAC. And the lot owners are a little bit apprehensive. I don't know, part of their argument is that really was unfair, because when Turnagain East was developed, they didn't have to go through some kind of a review by this Geotechnical Advisory Commission, and we think that maybe in doing that it delayed the work and made the work cost more. But nevertheless, it was in the ordinance. The municipality said back in 2004 that's the way it has to be. Brian Boss, who's with AWU, and he's in the Planning and Development Department, he testified that there was a great deal of communication regarding the construction between the municipality and the property owners. And you'll actually find that we've provided evidence of a lot of the meetings that took place.
Yeah, I think just doing a fine job. It may be beneficial, given the detail of the document and the scope of the project, if we just hit the specific findings. The body can go back, we'll have the document, we can read kind of what supports that. But I think we'll lose people just from the amount of detail involved in all this.
Okay, so let's do that. I'll starting on.
We can always go back if anybody has
Absolutely.
questions about a specific finding. We can go back and show you where in the document.
So we're going to move forward to page 19. And there's a subsection that's called B, the special assessments do not exceed the value of the benefit conferred upon the property. And that actually provides some law as to special improvement districts, and that they have to confer some sort of a benefit. And what it essentially says, the finding is based upon a review of the evidence before it, the Assembly concludes that although certain property owners did not receive benefits, the vast majority of the property owners did. That refers back to like the Hitchens, for instance, who owned a home and had all the utilities and the road access. But if the majority of the property owners did receive a benefit, gain, and advantage from the construction of the special improvement districts, and the special improvement districts do not exceed the value of the benefit conferred. So it goes on to provide some evidence that was considered to be substantial by the hearing panel, and it talks about the market value of those properties that are discussed, and it provides evidence given by the municipal assessor during the hearing, who demonstrated through various documents that these properties all went from a basically undeveloped tax assessment to a much greater, and in fact in some instances 300%, 400% greater after the construction was done. And so the document actually lists some of those and talks about how those increases were. So finally on page 24 at paragraph 60, it says, in reviewing the record, the testimony offered at the adjudicatory hearing, with the exceptions of certain properties discussed in the following section, the Assembly finds that the assessments did not exceed the value conferred upon the lot owners. So that's the first finding. And then section C on page 24 talks about how certain property owners did not receive, and that goes into this discussion about the Hitchens and the McLeods, and how the McLeods were treated different from the Hitchens, although they're in similar circumstances. And the municipality argues that really they're not the same, they're apples and oranges, there are some difference, and tries to distinguish that. But we're in going through and listing the evidence, the Hitchens finally did get a meeting with the people at the municipality, who said maybe we could do an equitable adjustment similar to what we did for McLeod's, but McLeod's adjustment was passed and adopted by the Assembly, and so we'll have to do the same thing. And so it was supposed to go in front of the Assembly, somehow it got dropped, and the Assembly never dealt with it. So the Hitchens have lots of emails and evidence showing all of their numerous attempts to get the Assembly to fix this problem. And so the finding is there that that the Hitchens home lot must be reassessed, and the assessed amount must be set at $2,656. This was an amount that the municipality had given them, which would be adjusted similarly as the McLeod property. And 84 on page 28 says that the difference in the final assessment, the Lot 10 Block B Simonson Estates subdivision, in the adjusted assessment shall be absorbed by A Group. And that was determination by the panel. So if they go back, see, in the meantime, what the Hitchens have sold their property and they have like $80,000 held in escrow that they're waiting to either pay these special assessments. The property buyer of their home would not agree to assume the obligations of the assessments. And so, anyway, that's the second major point on page 28. And then D on page 28 talks about this $1 million that shifted. And it gives all of the evidence and the history about what was actually going on. And it really highlights this, these geotechnical reports that said that for the subdrains, they have to be very deep. In fact, they have to be below the sewer line, which is the deepest line in the trench. And how that was peer reviewed by other experts, and how it went through the geotechnical committee, and they approved it with those conditions. And so it to the end of this one here.
It's probably the longer.
Page 45.
Yeah, it probably is, at least in the panel's discussions, probably one of the major issues that's there is this $1 million that was shifted and how that occurred.
Or was it alleged to be shifted?
Well, it was shifted. I mean, and I can explain that a little bit if anybody has a question, but it wasn't shifted improperly. So 164 at page 45 says, no, that's not the findings. So the findings on that basically are going to say within the body of what we've just passed through that the assembly, the panel found no evidence that $1 million was improperly shifted to the property owners. And I can explain that if anybody has any questions. And the next section, E, is where the panel went through the municipal bidding procedures and whether or not they were properly implemented. And so that shows a lot of the evidence that was presented. Basically what happened was around June of 2008 is when the bid was actually led. And within a couple of days, the municipality sent a letter out, and it showed the property owners how the bid package was put together. And it had a basic bid, and then it had these deductive alternates. And the deductive alternates were the special improvement districts. The basic bid included the pump station, but it also included parts of the improvement districts that needed to be considered in bidding as part of the basic bid. That's where that shift happened. So that it was bid out as not only the pump station, but also parts of the improvement district. And the property owners were a little offended that they weren't told of this beforehand. But, you know, obviously when you turn a matter over to the municipality and it has its people running the project, you can't really dictate or drive how that's done. It takes place. And the municipality explained why and justified why it did what it did. And the evidence all shows, and that's what this section does, that there really was no improper shift. It was done because the municipality was not certain whether the bids would come in under what the improvement districts were supposed to be. And if in order to bid it, it had to put all the stuff in the pump station under the basic bid, so that the contractor knew that if the alternate deductions or the deductive alternates were in fact passed, that money would then go back to the improvement districts. But in the meantime, the main goal of the municipality was to build the pump station, even if the bids for the improvement districts came in too high. And that's all explained in here. And so the finding is that there was no improper shift of $1 million. And then the finding on the other one that we just mentioned, which was whether or not proper procedures were followed as far as the procurement, the findings are that those two were proper. And that is on page 51. So under F, it says substantial evidence demonstrates that municipal bidding procedures were properly implemented, and it tells all the reasons why. So that basically then ends the review of the draft findings.
Are there any questions? Mr. Steele?
So this is our argument to the court, and
This is-
they're doing theirs.
Well,
in
no,
essence, we see
no,
that.
not at all. Not at all. What the court did was the court said the assembly has to have a judicatory hearing. And so this is the assembly's findings and conclusion.
Okay, I got
And
you.
so this will, the court will see this if this litigation that is still going on moves forward. And the court will have to review this and decide whether or not this does an adequate job of dealing with these issues.
Are the other folks preparing a document for that review also?
No, sir. The two attorneys already provided all their evidence, and they submitted their proposed findings
Yeah.
to the panel. And they've already done that. They're waiting for the panel now to
This
come
is
out
it.
with this. And this will decide the adjudicatory hearing phase.
So the court will just say you did it right, you followed the procedures, you did what we asked you to do,
Or not.
or not?
Yeah.
Mr. Evans?
Yeah, just to kind of encapsulate the whole thing a bit, the way I think most of it, Amy, Dick, and I looked at this, it was a pretty complicated matter. And the way it occurred over time, I have had great sympathy for the taxpayers in this case, because the way that that Pump Station 10 was incorporated into the project did cause a bit of confusion. It wasn't a very straightforward RID, LID, WID matter. The schedules, the bidding schedules that were used had elements from the Pump Station 10 in it because of the need for the construction process to go, and the municipality explained pretty well why it did it that way. But from a taxpayer's perspective, looking at it, it was fairly easy to see why they were suspicious. And I think Amy, Dick, and I all looked at it with sort of that suspicious eye. And I, going forward, I think it would be a good practice to try to avoid situations like this where you have a municipal project tied in to one of these RID, LID, WID projects. Just because even though it's efficient, it probably overall saved money for the project doing it in this manner, since it was both in the same area at the same time. It does lend to confusion and suspicion. And the project did increase from $3 million to $7 million. Again, the municipality explained that very well. It was basically inflation over that time period, plus the geological necessity of going deeper, which is always more expensive. So at the end of the day, while we felt that the taxpayer group was probably justified in questioning a lot of these things, they didn't get to the level where they actually were able to prove that there was a misallocation of costs from the Pump Station 10 to the improvement districts. And I guess that, and the other issue on the bidding, there was a big issue that where a number of the people in the district sent emails and notified the municipality after the bid was let to Pruse that they didn't want it to go forward. They thought that it was more expensive than it needed to be, partially because when in the season the bid came out, and also because of the inclusion of Pump Station 10 in the bids. They thought that drove up the costs. So they objected to that. They wanted it rebid. The appellants, the taxpayers, thought that should have put an end to the improvement district, because there is a provision in the law where you can withdraw your support from an improvement district under certain specified timelines. But we looked at that closely, looked at what they had submitted back then as far as their objections, and really what they were objecting to was the bidding process. They weren't saying they wanted out of the improvement district, they were just saying they wanted to rebid. And basically they don't have the control over that. That's the municipality's function, and we thought it was proper going forward in the way they did. That's all.
Mr. Trainee?
He covered everything. It's just also that what's going to happen now is this comes to the assembly for approval, and it's over with as far as we're concerned. So I appreciate the panel, the work you guys did.
Have the assessments been held up at this point, or?
Yeah, we have not approved the reassessments yet. Mr. Flynn?
Thank you, and thanks so much to you and Mr. Evans and Mr. Trainee for taking on a brutal task. I just want to make sure I understand some of these conclusions correctly. The way I think I'm reading this is we as in municipality are accepting differential between the assessment on the Hitchens property versus the more perhaps reasonable, which is going to be about $78K that we're going to ask Avery to pick up. That's, other than that, we're presuming the assessments are more or less accurate, and we'll reissue those.
Yeah.
Okay.
It's just that property had improvements in it before.
Yeah, okay. So I just want to make sure I understood all the findings here. And the other one, and this is not necessarily directly germane to this matter, but the Department of Law has drafted legislation that would turn this sort of issue over to a hearing officer in the future. I've asked Ms. Tucker to review that. And so we'll try to prevent us from having to be as directly involved in something like this in the future, presuming I can get it all done and seek and gain your approval.
It's interesting, just to speak on that, because we've gone back and forth as a hearing panel, whether it was a good idea just to do a hearing officer or to sit. And we both actually said we thought both were a good idea at one point or another. But the real value came, I think, when you actually had members of the assembly that were part of this hearing panel, because there's such a marriage between the legislative actions and the adjudicatory actions. So people really wanted the chance to sit, and they wanted you to listen, and they wanted you to hear their presentation. So I think a hearing officer, it was super complicated, there's no question. I think one day there was Tuesday, we had an assembly meeting the same night. I think we had put in a 18-hour
We started 8 in the morning, remember?
Yeah, but I think I was a little cranky by the end, but nonetheless, I think, either way probably would function well, but it was an incredibly complicated topic. But I think overall it went pretty well. Elvin?
Thank you, Madam Chair. I'd just like to take a moment to thank Mr. Levesque for his work. I really appreciate your explanation just now. It was pretty darn thorough. And I also want to thank the committee for taking on this enormous task, and I'm really glad that it wasn't me. But I want to thank you for all three of you for your work.
I'll put you on the volunteer list for the next one.
No, thank you, Madam Chair.
Thank you. Mr. Hall?
Well, we already have some expertise in that.
You're right.
Yeah, I will point out, just before, I'm sorry, Mr. Hall, I didn't interrupt you.
Go ahead.
Part of the reason the membership of the panel was as it was is none of the members of the panel were on the assembly when we took the legislative action. And so there couldn't be, we hoped, no preconceived notion of bias.
Except for I think Mr. Trainee may have been on at some point during one of
He was
us.
Every now and then.
Back in '94.
Well, before and after.
Yeah.
He was on during the earthquake.
He was on.
I'll get you later.
I feel vindicated in what has been decided here because I was very involved in this. It is in my district. This came up right after I was elected. So early on, I got to deal with this. And honestly, I was the one that said to the body, and said, yes, we've really reviewed this, we've looked close, and this is right. And it's pretty obvious that it's pretty well come down exactly that way in the end. So I feel very good about it. I think it was exceptional that the three of you were the ones that got to deal with it because you weren't on the body at the time, and it couldn't have been any more fair for anybody involved. But I am leaving here going, wow, early on, but maybe I did get it right that first time.
Don't break your arm.
And one of the things that I'll point out, we had a lot of testimony. There was some complications with the bid. So at no point, though, did anyone come back when the bid was let out and they saw issues. Number one, there was only 2 bidders, and one of the bidders made a substantial error in their bid. So one of the bids came in $2 million less than the other bid. And so, the purchasing officer, obviously, I don't know if that's the right title, but this municipality obviously realized there could potentially be a mistake. So they asked Roger Hickle Contracting to double check, and they can't just say yes. They actually have to prove to the city that there really was a mistake in the bid, and they could not perform the project for the cost that they had said they could initially. So they were allowed eventually, through the correct procedures, to withdraw their bid. So that left Cruz as the only successful bidder left. And so they were awarded the contract. But nowhere during this time did anyone from any of the correspondence we saw in the improvement district say we withdraw our support for the project. There was no attempt from the property owners to nullify or to reject the LID, WID, or RID projects. And that's where it goes back to what Mr. Evans said about they had a problem with how the bids were being bid, but they never withdrew their support for the actual improvement districts. So we found that was substantial. And I'm trying to think of what the other major issue is. I think that was really the biggest issue when it came down. Mr. Peterson.
Thanks, Madam Chair. So did they think that this should have been started over, that it should have been rebid from the beginning? And since it wasn't, they thought that they got charged, or the project cost more than it should have?
Well, I think what it came down to is they didn't want Pump Station 10 being built at the same, being bid concurrently with the RID, WID, and LID. Was that what you were going to say?
Well, yeah, there was a couple things tied into it. By adding Pump Station 10, they thought it limited the number of vendors who would bid for the work, because it wasn't strictly just a road project, and they thought that if it was just a road project and the others, they'd have a broader base of people that do that kind of work. By including Pump Station 10 within the ambit of the bid, it limited the number of contractors that could do both. So they thought that drove up the costs.
Mm-hmm. And the other thing I'll point out is it was very important to understand on the ballot the second time when this area voted to affirm these districts, the cost was there, and the landowners, property taxpayers, never at any time have had to pay more than they approved. So that was substantial as well. Mr. Train?
Just in some cases, I think they wanted a different contractor to win the bid, and they were not happy with how it ended up. But the city followed the correct process, followed the right procedures, and awarded the contract.
Mr. Flynn?
Well, I just note, this was a time of relatively robust activity. Even Bruce bid was under the engineer's estimates, which is pretty impressive, frankly.
Yeah, it really was. Part of the testimony was talking about, the inflation at the time, the skyrocketing costs of materials, and so it was very complicated. It's not like it was bid one year and the next year it happened. This went over a period of time. So I think that was important. But the one thing that we did find that we felt we needed to correct and validate is the Hitchens, this property that we were talking about. These people already had road access, water and sewer, yet their neighbors right across from them had the same, and they were only charged less than $2,000, where they had to put in an escrow $80,000. So these two properties that we viewed and we found to be similar the municipality, it seemed at times, and testimony and email correspondence validated the fact that the Hitchens unfortunately fell through the cracks. We found that the municipality initially, it looked like there was intent to give them parity and treat them equally with the McLeods, but for some reason it just ended up not happening. So we felt it was appropriate to treat these two landowners similarly. Mr. Trainee?
That's exactly right. It got dropped along the way for whatever reason, whether it was a assembly member from that area or what it was. They just, not you.
It was a different name that was
It was
referenced.
a different assembly member, not you.
Not you.
But it just got dropped. And they kept waiting to get some resolution on it. It never happened.
Right.
Chair.
So,
Just 2 points I wanted to just add. There's a third property too. Early on, the municipality identified 3 property owners that had homes with road access and utilities. And Mr. Quist is still, I need to add something in there. It's a little confusing because he sold his property and he's never complained that I can see in the record about that property. He's only complained about 2 lots that he had, that prior to the actual vote and prior to the assembly action, he was attempting to replat his property so that he only had 1 lot instead of 3. And he failed to do so timely. So those 2 lots, received a benefit. They're all hooked up now. But the other thing that I wanted to point out was that when the bids came in, at least 3 of the property owners went to the municipality and said, can you do a comparison of this bid and other ongoing public projects? And the comparison came back, it's within the range, it's 2% different from last year's numbers. We don't have this year's numbers.
And I would say just, because the remand that came back from the court was so heavily on due process, we went to painstaking effort to make sure that everyone had the opportunity multiple times to speak. And during the hearing, the formal hearing, that's when the quiz came down and they had the opportunity. So not only did you have the attorneys, you had public had an opportunity, anybody multiple times who wanted to speak before us and bring us evidence, testify, just comment. Everybody was afforded that option. We worked diligently with both the appellants and the appellees to set up a fair process, one that they both agreed to as we went forward. And I think you see that through all the stipulations that we talked about at the assembly meeting and all those things. So I think this was definitely, I think they were afforded due process. I think it was fair for both sides. Everybody had opportunity to address the hearing panel. And I think in the end, we came up with a very sound and fair and legal finding.
So,
Mr. Peterson?
thank you, Madam Chair. So going forward, are we anticipating that they're going to file an appeal?
Well, you never know. You never know. So ultimately, what happens is the hearing panel's findings are final. I mean, this is what we found. We are going to present it, and it will be entered into the record. And then once this is entered into the record, then we'll have an opportunity. Then the tax assessment rolls will come back before us as a body. We will take public testimony again, and then we'll close the public testimony and we'll vote on the tax assessment roll. Then after that, if the appellants if they disagree or they want to bring it back to court, they'll go back to court and they have to show somehow that we didn't comply with the court remand, which we feel like we did. So, Mr. Wheeler?
Madam Chair, thank you. Dennis Wheeler, municipal attorney representing the municipality in this proceeding. Mr. Owens could not be here, so I offer my apologies for that. This is a work session, but it's also part of this adjudication process that Mr. Levesque described. So I would like to know if I could just speak for a minute or two. It's all right with you. And it's not an advocacy piece. I just want to know if I have a sort of a procedural question.
Sure.
Okay.
And just for the record, I don't see Mr. Staley or any of the appellants here today.
So, the municipality would like to be able to have a copy of the decision. I know it may be not 100% final, but we could get a copy prior to Tuesday night so we have a chance to review it, because we'd like to be able to make comments and suggestions perhaps Tuesday night, rather than file a motion to reconsider and have you guys come back and deal with this again later.
It's our intent to hopefully have this finalized and on the web by Monday. That way, both the appellant and the appellee have an opportunity to review it prior to public testimony.
Great. My expectation is municipality will only have one request. That one request, just so you are kind of have a heads up on it, is this. We don't take issue with your decision regarding Hitchens, except that we would rather you not recommend that the costs go to AWU, because Hitchens involved a road improvement district, not the water and sewer. So the municipality will simply absorb that cost through Public Works, PM&E, not through AWU, which would make that hit the AWU rate.
We can change it.
Makes sense.
But we'll
Okay.
do that to in a formal writing, if we have a chance to see the decision, so we can make all the proper references to the decision. That
Well,
way, we're not gonna be able to do that before Tuesday's meeting, so we don't have to file it, and you have to come back after Tuesday to take it up.
Okay, we'll take that under advisement.
Yeah, I'll talk to the panel about it.
Great, thank you.
Mr. Evans?
Do we know exactly what the process is going to be Tuesday as far as how this is going to work, due process-wise for everything? I'd like to make sure we're on the same page before we get there.
Right, so my understanding is the hearing panel findings, after the three of us sign them, they're final. That's what the findings are. And then they will be on the agenda for the assembly to accept the findings. It's not my understanding that the assembly can amend our findings because they weren't the hearing panel. Does that make sense?
I agree with that, Madam Chair. The one question that I had, and you'll look at the back of this document, it has it listed exactly as Ms. Dombowski described. It will have signatures by the three panel members, and then it has an adoption signed by the chair. The one question I had is whether or not you really want the chair to sign on behalf of the assembly approving this.
We could have the vice chair sign. That would probably be
She can
more
do it.
appropriate.
Right, because he sits on the panel, and it seems awkward to me, but.
I think that would be more
She can
appropriate.
sign it.
We'll just list the vice chair then.
Which is L.B. Gray
Yes.
Jackson.
Ms. Gray Jackson?
Thank you, Madam Chair. So are we still prohibited from talking about this?
Yeah.
Okay.
Until
I
it's
just
done.
Until
it's done.
passes
Okay,
the assembly.
until
I
it's
think.
Adopted.
So,
Adopted.
adopted, thank you.
Yeah.
Not that I want to, but anyway.
Let me just, in response to that, you still should have no ex parte communications with anybody. This decision is based on the record on appeal, as well as what happened at the adjudicatory hearing.
Mhm.
And before you adopt this, if you're talking to, your constituents, that none of that evidence was before this panel.
Right, and can I follow up,
Yes,
Madam
ma'am.
Chair? Yeah, and I'm not talking to anybody, I just happen to have a friend who's part of this, and we don't talk about it.
It's a good
Yeah.
question because when is it really final? It's final, I think, once the assembly accepts it.
Sure.
Approves it.
Yeah, they accept
And Ms. Dombowski, I'm going to
Thank
ask
you.
you, once this passes the body, for you to move for immediate reconsideration, urgent no vote. Normally I don't want you to do that, but in this case.
Mr. Evans might come unglued.
I will come unglued.
I do not want somebody the
We'll
day
glue 'em
after
back.
we make our.
Okay.
Fine with him.
I'll talk with
We'll
assembly
glue 'em
council about
back.
procedural issues. Yes,
Welcome,
Mr.
Luke.
Hall.
Actually, for my own edification, I would guess until they withdraw this from the court, even when we make a decision, there still may be litigation pending on this.
True.
So
Correct,
it would
that's
be
true.
my guess, we can't do anything until that final decision is made to the court.
That's probably
I
very
would
good
agree.
advice.
I think that's prudent.
And so procedurally, what we'll do, sorry, Ms. Jones, do you want to go?
I just wanted to make sure I heard something that I quickly checked. I want to make sure that we all have the same understanding. On the agenda on Tuesday are the public hearings on the new assessments. But adopting this findings of fact and conclusions law is not on the agenda for Tuesday. And I don't remember exactly, but I was thinking it may be on a future agenda, but it is not on the agenda for Tuesday.
Can we check and figure out when this comes up?
I believe Ms. Dombowski may have the schedule in front of her. Is that correct?
the Assembly's decision on the corrected, the only thing it says, it talks about the public hearing on the corrected assessment rolls are March 3rd. And, but the Assembly doesn't have to take action until March 24th. So we weren't sure exactly when we were going to get this done, I think is what it's coming down to. And we can't take action on the Assembly rolls, tax rolls, until this is accepted.
Until this is approved.
So, there's a couple different ways we could do it. We could introduce this on Tuesday and delay action on it. I mean, this isn't open for public testimony, so we could also, lay it on the table or
action on Tuesday.
We can
Yeah.
open the public hearing on the assessment.
Yeah.
And continue the public hearing, because
Yeah,
we're first going to
Barbara?
take action on this before there's any new rolls.
Ms. Demboski, would it be possible if you, Mr. Levesque, me, maybe the rest of the panel, confirm the procedural process
Sure.
on this offline?
Sure. Thank you. But in the end, what happens, we'll take public testimony on Tuesday.
We can't take action.
Well, we can't take action until we actually adopt or accept the panel's findings. Does that make sense to everyone?
Mm-hmm.
I agree.
Yep.
So we will solidify that for everyone and then get back to you. Are there any other questions, comments, positive remarks?
Negative remarks. Aren't you glad you didn't have to be on the panel?
That's what I
All right.
said. More than
This
once.
hearing's adjourned. Or,
You know,
Workshop.
I'm
Work
really
session.
thankful, you guys.